So we're here now with Alex Ghibaudo. He has a law firm in Las Vegas, Nevada. Why don't you let us know a little bit more about your firm and also some of the areas of law that you regularly practice?
Practice primarily in the area of family law. We also do criminal defense, appellate law, and civil litigation, but mostly family law.
After providing coverage of the state of Nevada versus Michael McDonald, we started to put together a list of some of the more frequently asked questions that the viewers were posting to our videos. One of those questions had to do with the reasons as to what defense counsel was asking for when he moved for an advisory verdict.
Okay, so in Nevada, at the conclusion of the prosecution's case, the state or the defense cannot move to dismiss based on the insufficiency of evidence. That claim needs to be made in the Court of Appeals. So what they can do instead in Nevada is ask the court to render its verdict based on, the argument is that the evidence was insufficient. Can you let the jury know what your verdict would have been? Presumably saying, in my opinion, there's an insufficient amount of evidence to convict the defendant. That's what they were asking for.
So this wasn't actually something that the district judge could have imposed on the jury.
Jury's under no obligation to listen to it at all. They can do what they want given that verdict, given that advice. That's why it's an advisory verdict. They can take it or leave it.
That must be, and I'm just guessing here, but that must be what distinguishes it from a directed verdict.
Those are in civil cases, so that's what I'm saying. In this case, what's not available is a directed verdict where the judge can essentially superimpose its own view of the sufficiency of the evidence on the jury. Rather, that would have to happen at the appellate court after the jury rendered its verdict.
So for our next question, and this is probably the most frequently asked one, how much time is the defendant facing?
Yeah, that's provided by statute. So what Mike's facing is 3 counts burglary, or what he was convicted of is 3 counts of burglary, 3 of forgery, 3 of offering a false instrument, and 2 of perjury. The burglary charge is a category B felony, so it carries with it the possibility of a minimum of 1 year, maximum of 10 years in prison. The category D felony, which is forgery, would be 1 to 4 years plus a $5,000 fine for each charge. Offering a false instrument is 1 to 5 with a $10,000 fine, and then perjury is a 1 to 4 with a $5,000 fine. So how much time he faces depends on whether the sentencing judge runs those charges or those sentences concurrent or consecutive. If they're consecutive, basically what you do is look at the greatest felony, which in this case would be burglary. Because he's facing 3 counts, it would be a minimum of 3 years, maximum of 30 years. And then if that's the case, let's say for example the judge decides the proper sentence is 4 to 10 years, then everything else runs concurrent to that. So everything just falls under that, and when he's completed that sentence, he's completed the sentence for everything else. If they run it consecutive, they just stack everything up. So if he's got a total of 10 charges, it looks like minimum of 1 year for each one, so his minimum sentence is 10 years. And the maximum sentence would just be the maximum of each individual crime. So you could be looking at minimum of 10 up to a maximum of forever. 60, 70 years, whatever that is.
A handful of viewers keyed in on the physical struggle between Mr. McDonald and the marshals in the July 22nd, 2019 revocation hearing. Court staff and even the judge gave the defendant a wide berth. In fact, I believe the judge vacated the courtroom entirely, but the defense attorney, Mr. Craig Mueller, stayed nearby. He seemed very calm, and a couple of viewers actually asked whether or not this was sort of an instinctive...
I think it's simple that he knows Mike, He knows that he's basically harmless. Nobody else knows who Mike is. They just know this guy's freaking out in court, and they assume the worst. But as a defense attorney, you get to know your client, and when they freak out like that, you see it for what it is. He's just freaking out, and they'll get him under control, and it's a wrap. So he's not gonna, necessarily freak out himself and make things worse. Maybe he'll stay there and try to calm him down. Similar thing happened to me with Mike in family court, where after the conclusion of the initial motion to modify, he freaked out and started screaming at the judge. I put my hand over his mouth, and I put him in a chicken wing and just shoved him out of court. So I wasn't, everybody else was scared, but I knew Mike. He's a harmless, he's big, but he's Mike. I'm not impressed, I'm not scared of him, but if you don't know him, he's a big dude.
On multiple occasions, the viewers noticed that the jury was either not present or asked to step out when questions arose involving some of the social media organizations, for example, Veterans in Politics International and Nevada Court Watchers. And the question there is why?
Well, because the only thing that's at issue is whether Mike committed the crimes that were alleged. If you start bringing in extraneous evidence like that or background evidence, the analysis is whether that evidence is relevant or not. And it's really, the way you look at it is its probative value versus its prejudicial effect. Does it have any probative value, the evidence that needs to be adduced to satisfy the elements? And if the evidence is minimal and its prejudicial effect on Mike is greater, then it's irrelevant and it doesn't need to be in front of the jury, so as not to poison the jury.
So the last question has to do with the amount of time that the court and the attorneys spent on the jury instructions, specifically what was referred to as a specific intent instruction. Would you have some insight there that you could offer?
That's a complicated answer, honestly. So there's two types of crime. Every crime requires the state to prove beyond a reasonable doubt an element of intent. There's different levels of intent. You have general intent crimes versus specific intent crimes. So an example of a general intent crime would be battery. Generally had the intent to cause the other person harm. Whether you specifically harm them or not doesn't matter. With burglary, it's a specific intent crime, so you have to prove beyond a reasonable doubt that Mike intended to commit that crime before he entered the building. So if it was like a general intent, they would just have to prove that he generally had an intent to commit a crime, and it didn't matter if he intended to do that before or after. It would have made it a lot easier for the state to convict him.
Is it noteworthy there to also bring up the consequences of allowing an erroneous jury instruction to get sent to the jury? Is there...
Well, yeah, because remember, they're essentially conducting a legal analysis, the jury, right? And so if given the wrong standard, then the analysis is all wrong, and there's going to have to be a reboot.
Thank you so much for your time, Alex. That wraps up all of the questions I had, or I guess I should say the viewers had.
All right, no problem. Thank you, sir.